Today we're going to talk about your notice to vacate. Now, this is an extremely important document and one that so many landlords get wrong. In Texas, in order for a landlord to demand that a tenant vacate a property, whether it is a commercial property or whether it is a residential property, a notice to vacate must be delivered to the tenant in writing. Most landlords get that part correct. What they fail to do is to supply the tenant with an adequate notice to vacate. Well, what makes a notice to vacate adequate? Well, Chapter 24 of the Texas Property Code informs us what the legislature has set out as the guidelines for a landlord to establish a good written notice to vacate. However, many landlords have either a pre-dated or outdated version of this notice to vacate saved on their computer or stored away in their file, and they recycle that old notice. And they'll tell me, well, Ernie, I've used this same notice for 15 years and it's never given me a problem before. Why did this court rule out of my favor? Well, the fact is, you're not always going to get caught by the courts on a bad notice. Some courts are more diligent at reviewing these notices to vacate, and others are not. Where you'll find the greatest scrutiny is on appeal. And when these files go before the county courts, the courts there, the judges, you're going to find when the files get to the county courts, the courts there give a greater degree of scrutiny to your documents because the county courts are courts of record, whereas the justice courts aren't. And because of that, a greater degree of review will be paid to these documents. Your exhibits will have to be numbered and entered into the court. And it's at that point where the judge may, on his or her own, determine that you failed to deliver proper notice. And because of that, you're not entitled to possession. So your notice in Texas should be an unconditional demand for possession. What does that mean? Well, it means that you should, in your notice, be telling your tenant to leave without any doubt that you are demanding possession. Many landlords file notices that give tenants options. You'll deliver a notice, perhaps it says, I hereby ask you to pay or quit. It's a common notice, but it's one that some judges simply do not like because it's not an indisputable, undeniable, absolute demand for possession. And so in order to deliver that unconditional demand, we suggest that you do not give the option to the tenant to pay or to leave. Instead, you make an absolute demand. You are hereby demanded to vacate the premises. If, however, you later make some kind of arrangement with the tenant in exchange for payment or some other value, you withdraw such a notice or you update the notice, you have every right to do this. But the notice itself should be an unconditional demand for possession. As far as the time, refer to your lease contract. Your lease contract is going to explain, or it should, a well-written lease should explain how many days of notice are required to give to the tenant. Generally speaking, the default is 3 days notice. If your contract is silent in that respect, you must give at least 3 days of notice to your tenant. Now, different courts count this in different ways, so I'm going to give you the rule of thumb that I counsel clients with. If you personally deliver the notice to vacate and it is an adequate demand for possession, if you personally deliver it to your tenant in their hand, the day that you deliver it is day 0. So let's say, for example, that's on a Monday. Day 0 is Monday. They have Tuesday, Wednesday, and Thursday to vacate. Now, that doesn't mean that Thursday at 8 a.m., which is the third day since you delivered the notice, you can file the eviction. Always regard the day you hand deliver the notice as day 0. In this case, it's Monday. Day 1 is Tuesday. Day 2 is Wednesday. Day 3 is Thursday. At the completion of day 3, if the tenant has not vacated, then on Friday of that same week, you are free to file your eviction. Again, read your lease carefully. Some leases give additional time. Some give less time. To be certain, review your lease. If you have any questions regarding the interpretation of your lease, speak to a licensed attorney. As far as the methods of delivery of a notice to vacate, the courts offer very specific methods. We're going to talk mainly about two. They're the two that I recommend the absolute most. We're also going to talk about one method that I never recommend. The two that I recommend involve personal delivery and then delivery by mail. And then we'll get to the one that I tell you to stay away from, absolutely. We'll get to that one last. First method, if you're going to deliver a notice to a person in person and leave it in their hand, that's a good and effective method of delivery. However, that person has to be a named tenant on the lease. Generally speaking, if you knock on a door and the named tenant answers and you leave the notice with them in their hand, you've accomplished what the courts require with regard to delivery of a valid notice to vacate. Where people get in trouble is where they leave a notice with, say, the boyfriend or mom or a small child. These are not methods that we encourage, and because of the possibility that a tenant can claim, I didn't get the notice, but my friend was visiting at the time and she mentioned something about a knock at the door. Unfortunately, leaving a notice with a party who is not named on the lease or who is not actually a resident of the property can defeat whether or not you have delivered good notice. And it calls into question. So while we do recommend this as an adequate means of delivery, it's not the best. The best method of delivery is by regular and certified U.S. mail. Now, this is the method that we employ in every one of our eviction filings because, number one, regular mail cannot be rejected by a tenant. Number two, certified mail can be tracked. And so because of these two facts, we can use the delivery of a regular and certified letter to a tenant and prove those facts simply by going to USPS.com and following the tracking. In every case that we've presented, this information has proven effective to establish the dates and times when notices to vacate were delivered. Now, the method that we strongly discourage is one that is still technically legal in the state of Texas, but only in a very, very narrow situation. And because it is so narrow, we discourage strongly anyone from employing this method, and that is a delivery of a notice by taping the notice to the outside of the door. Now, generally speaking, this has been a method that some landlords have employed for years. But this method is no longer recognized except in a very narrow situation. And because it is so narrow, I'm not even going to take the time to explain it. I'm simply going to tell you, don't do it. The law does allow you to deliver a taped copy to the inside of the door. However, the reason we don't generally recommend this method of service is because it's very difficult to prove. It's very difficult to testify that you open the door and put it in there if someone says, no, that didn't happen. Now, some courts are perfectly comfortable with that. But what they're not comfortable with is taping it to the outside of the door. I've seen landlords jam a notice into the side of the door to slip it underneath the door. I've seen landlords tape the notice to the mailbox, to the door. I've seen them tape it to car windows. None of those methods are effective and we don't recommend it. The best method is to use regular and certified mail. If you have questions about a notice that you've delivered or about a method that you are interested in discussing, contact a real estate attorney. You can call us at our office. We'll be happy to supply you with what we believe and understand is a valid and effective notice to vacate that you can use over and over and over again. Additionally, we can suggest methods of delivery that are perfect for the situation of an eviction filing. Again, any questions you might have, contact a local real estate attorney.